your grand entrance. Here, you can sit
Where would you like to sit?
right here.
Thank you so much.
Hi everyone, thank you for sticking around. I always feel, this is my second time seeing the film, and I feel like I have to catch my breath, so forgive me as I do that. My name is Benna Jensen, I use he, him pronouns. I am the Director of Legal at EGAL Canada, and I'm so honored to be able to help guide this conversation among three incredible characters in the film, as well as individuals in their own right, of course, and I'll introduce you to them in a moment. I think just a word about our work at EGAL. We're a national organization that's existed it was founded in the 80s during this time period, and I think, and in my day job, I'm involved in leading the litigation in Alberta and in Saskatchewan, all the responses to anti-trans policy and legislation that we're dealing with today. And I think that this gift for me is just such a beautiful, or excuse me, this film is such a gift because I feel like it has allowed me to walk alongside the advocates who paved the way for me to be able to do the work I'm doing right now. And so I'm just so grateful for that. So now I have to check my notes to make sure I don't mix up the details of bios. So, well, I also know their names, so I can just start with that part. So to my immediate left, we have the film's director, Darren Hagen. I'm thrilled to have him.
Thanks for coming out today, everybody.
So in addition to directing this incredible film, Darren's an award-winning playwright, author, composer, and performer, and queer historian. He has created over 40 plays and dozens of published essays and articles, mainly dealing with the history of sexual minorities in Alberta. And we're extra lucky to have him right now because he had an opera open this past weekend, and Shakespeare in the Park, which he's also responsible for in Edmonton, is opening tonight or happening tonight?
Tomorrow, I'm missing it. That's all I know.
He's here. To Darren's direct left, is Justice, Cynthia Peterson, who keeps wanting me to call her Cynthia, but I am struggling. She was a law professor for 5 years and a lawyer for 22 years before joining the bench as a judge of the Ontario Superior Court of Justice. In the Vriend case, she represented EGAL Canada. It had a slightly different name, but EGAL at that time. So I'm extra honored to have her with us. In private practice, she also represented individual, lesbian, gay, bisexual, and trans clients in numerous groundbreaking human rights cases and charter cases at every level of court in Canada. And you may recognize, our last but not least panelist to my far left, you may recognize from the film, not having aged a bit.
I know. Like, what's going on there?
Lyle Caney, he appeared before the Supreme Court of Canada in Vriend as counsel for the intervener, the Canadian Jewish Congress, and we heard his beautiful words in the film. He was a partner at the Edmonton labor and human rights firm, Travis Greglo Caney, which represented Delwin Vriend before the Alberta Court of Appeal and Supreme Court of Canada. And after 2 decades representing trade unions in Alberta and Ontario, Lyle became a labor adjudicator, arbitrator, and mediator. He was the recipient of the Alberta Human Rights Commission's Susan Ma Award for Outstanding Leadership in Promoting Human Rights Principles and Ideals. And with that, we'll get started. Thank you for being here. So, Lyle and Cynthia, I'll start with you two together in turn. Can we start by having each of you share a little bit more about your involvement in the case beyond what we know in terms of who you represented, and then any color you can offer about the case in that moment in time? Maybe we'll start with you, Cynthia.
Thank you. I want to say congratulations on the film. It's the first time that I've seen it, and I am catching my breath.
It's a little overwhelming, isn't it? And I have to say, I've never met Lyle before or Cynthia, and I heard all about them from Doug Elliott, who sings your praises highly.
And I'm sorry that Doug isn't here tonight.
I know.
I was hoping to see him. I do see, incidentally, some of the other lawyers who are in the Supreme Court who are here from my old law firm, Stephen Barrett, Eitan Postkanzer. I don't know if Vanessa is here. She's not. I did see her in the film.
Group photo afterwards.
Shar Weissman, and they're there may be others. It really was a team effort in terms of the legal team. I do want to say that when the case went to the Supreme Court, that moment in time, in terms of the arc of the Supreme Court's jurisprudence, it wasn't clear that we were going to succeed. The way that the film shows how well the hearing went, sure, we started to feel positive once the hearing had taken place, but that case was argued in the Supreme Court of Canada in November of 1997. In May of 1995, so was that 18 months earlier, the Supreme Court of Canada had heard another gay rights case involving Egan and Nesbitt. Some of you may know they were an older gay couple who lived in British Columbia, and they had brought a challenge using the charter to the Old Age Security Act in Canada, which at that time granted spousal benefits to heterosexual couples but not to same-sex couples. And they had won an important victory in the sense that they got a majority of the Supreme Court of Canada to say that the charter protects gay people from discrimination on the basis of sexual orientation. But the case was not successful, and EGAL was involved in that case. I represented EGAL in that case. And the case was not successful because 5 out of 9 judges, a majority of the court at the time, this is only 18 months before the Vriend case, said that although it was discriminatory, it was justifiable discrimination. It was reasonable and justifiable discrimination. And that decision was written by Justice Sapinka, and I actually did bring some notes because I didn't want to misquote the decision, who said, among other things, equating same-sex couples with heterosexual couples is still generally regarded as a novel concept. Provincial human rights protections against discrimination based on sexual orientation is of recent origin. The court should not use the charter to second-guess Parliament's judgment as to how quickly it should proceed in moving forward toward the ideal of equality. And finally, the recognition of human rights emerges slowly out of the human condition, and Parliament should be permitted to take short and incremental steps on the long journey towards full and ungrudging recognition of the dignity of the human person. So basically, 18 months before we went to the Supreme Court to argue this case, the Supreme Court, or a majority of the Supreme Court, said, you need to be patient. It's going to take some time. We can't push the legislatures to do this. So that was not a runway to success in the Vriend case. And I was worried that, and interestingly, Justice Sapinka, who wrote that decision in the Egan case, didn't participate ultimately in the decision in Vriend, and it would have been interesting to see what he had to say. So that's sort of one point I wanted to make, is there was that moment in history. And if you'll indulge me, the other thing that I think is so important about the Vriend case, apart from it's an obvious milestone in LGBT rights evolution in Canada, which the film made very clear, is it's also a really important case in terms of underscoring the role of the courts in a constitutional democracy, because it was a case where the Alberta government and the interveners in support of the Alberta government, which incidentally included the Ontario government. So in Ontario, we had protections against discrimination based on sexual orientation. We'd had them for more than a decade. And still the Ontario government was there to support the Alberta government in this case, because those governments and the other interveners who supported them were saying, well, a number of things. One of the things that they said was, this isn't government action. The charter applies to government action, right? So when state actors, whether it's the police or the legislature or the executive branch of government, when state actors do things to violate your rights, you can use the charter to challenge that. And they were saying, this isn't state action, this is state inaction, right? This is a legislature making a choice not to legislate about something. And so the charter doesn't even apply. There is no charter scrutiny. So that was one of the arguments that they were making. And that was rejected unanimously by the Supreme Court, that said, no, when you make a deliberate decision not to include a particular group in protection that is offered by a statute, then that's a choice, that's a deliberate choice, that constitutes action. But the same theme came in when it came to remedy. So yes, the court unanimously ruled that this is discrimination and it's unconstitutional and it's not a reasonable justifiable limit. But there was a dissent, which isn't really discussed in the film, by one of the judges, Justice Major. And he said, you know, it should be left to the legislature to decide what to do about this. And he actually said in his judgment, the legislature might prefer to have no human rights legislation at all than to add sexual orientation to the grounds that are prohibited. That, you know, it's not for the courts to tell the legislature how to fix this. And he also said in his judgment, the legislature might want to invoke the notwithstanding clause. Now, he was a lone voice, right? It was a decision that was 7-1 ultimately, so he was a lone voice. But I would encourage all of you, and it's very easy, you can just Google Vriend versus Canada and the decision comes up, to actually go and read the decision that was written, because it is a really eloquent articulation of the essence of a constitutional democracy. So you have Justice Iacobucci, who you saw in the film, talking about how, and again, I don't want to misquote him, so if you just give me a moment, I'll find it in my notes. So he talked about how in 1982, when the Charter was adopted, the Canadian people, through their elected representatives, made a decision to adopt a Charter of Rights. And when they did that, they redefined what democracy meant in Canada. Because it meant that from that date forward, legislatures and the executive branch of government would always have to conform with the Charter, and the courts would be the trustees of those rights. So if there were any disputes about the interpretation of the rights or the scope of the rights, the courts were the ones that would be entrusted with making those decisions. And it's precisely because judges are unelected and because judges have judicial independence from government that citizens and the litigants who come before the courts, and this is, I'm paraphrasing, but this is more or less exactly what Justice Iacobucci said, that citizens and litigants can rely on the courts to make reasoned and principled decisions according to the dictates of the Constitution and democratic values, even if those decisions are not popular or are controversial. And Justice Corey, who you also saw briefly in the film, also wrote a part of the decision. And he said, because there was a framing of the case particularly by the Alberta and Ontario governments, but also some of their supporters. There was a framing of the case saying, you know, basically this is a fight between elected representatives in the legislatures and the powers that they have, and these activist judges who are overstepping and who are interfering and telling the legislatures what to do, these unelected activist judges. And Justice Corey said that's not an accurate way to frame what's happening in this case. And he made the point that it's not the courts who are limiting the legislatures. It's the Constitution that limits the legislatures. And it's not only the court's role to make sure that legislatures comply with the Charter, but he said it's the court's duty in a constitutional democracy to do that. And the court has to do it. And for me, the Vriend case, it's a hugely important milestone in the evolution of LGBTQ rights in Canada, but it's also a really important articulation of the importance of judicial independence, the importance of the rule of law, and what it means to live in a constitutional democracy. And I think it should be taught in every high school class for that reason. And those are themes that really resonate today in the world today.
When you said activist judges, the hair on the back of my neck went up because it's something we've heard so much the last little while.
Thank you.
Thank you so much, Lai.
So in terms of my own personal experience, I was just thinking how fortunate I've been in my career. I've worked with 3 law firms. First law firm that I worked with, one of the members of the firm was the vice president in Alberta for the Canadian Jewish Congress. And he made the important decision to encourage the Canadian Jewish Congress to participate as an intervener. Second law firm that I was working with was the Chivers Greco Caney firm, and I was partnered with Sheila and Joanne, who were clearly the driving force behind this legal project. And then, a number of years later, I joined the Zach Goldblatt firm in Toronto and was a partner with Cynthia and Stephen and Eitan, who were instrumental as brilliant advocates at the Supreme Court on behalf of the Canadian Labour Congress and EGAL. So watching that film has made me just, be reminded how lucky I have been as a lawyer.